I'm sorry, I didn't.
No, there's, certain words that I need to say.
Right.
So
Thank you.
on the verified petition of Barbara and proper notice having been given to all interested parties, James is nonverbal. Yes, okay. I just, there's, certain words that I need to say. Right. So I've got to stop for 45 seconds while our YouTube catches up. So we've got to wait for 45 seconds.
Set up.
I've got to stop for 45 seconds while our YouTube catches up. So we've got to wait for 45 seconds. Okay, so now proceeding forward, based on the verified petition of Barbara Hines, who is the biological mother of James, and proper notice having been given to all interested parties, James's father, now deceased as of January 20th, 2017. Barbara is seeking adjudication of disability and appointment of herself as the guardian of both the person and the estate. Court finds as follows: that the petitioner, Barbara, is present and having testified and filed a verified petition. She's over 18 years old, a resident of the United States, of sound mind, and not having been convicted of a felony. The respondent, James, is also present by Zoom. The respondent was served with a summons, and as I mentioned earlier, all of his relatives have been given proper notice. There's no powers of attorney existing or agents currently serving. I'm going to waive the necessity for an appointment of a guardian ad litem, as it is not necessary for the protection of James. Upon review of the doctor's report, the testimony of the petitioner, the communications and observations that I've had today in open court of James, I'm going to make a finding that it's been established by clear and convincing evidence that the respondent, James Hines, is a disabled person pursuant to the definition of the statute, and the appointment of Barbara as the guardian of both the person and the estate of James is necessary and appropriate. So, counsel, you're going to prepare the order of plenary guardianship, including those findings, and you're going to submit it today by email to cc201@lakecountyil.gov, and you're going to send that order today to the attention of Tamara, Tamara.
Judge, thank you. May I just clarify, may I include in that order the authority to continue to residentially place?
Yes, you can. And Barbara, so nice to meet you. James, so nice to meet you.
Thank you.
Glad that James is in a
Thank you. Jimmy, you want to say bye?
Not particularly. It's okay with me. Have a nice day.
Thank you, Judge.
Okay, thank you guys.
Thank you.
Thank you.
Bye-bye.
Estate of Chase Johnson.
Good morning, Your Honor. Vasily Ristos of Kelleher and Buckley on behalf of Jennifer Johnson. Frankly, Your Honor, we, as a little background, we had received a call from Jennifer. Jennifer, we're handling some other matters for. Long and short, and I'll give you the chronology. Last Thursday, Chase ingested about, I don't know, a number of Zoloft pills, probably in an act of, of suicide or some harm against himself. Was discovered. It ended up being Jennifer was not in the house at that time, but Chase was taken to Good Shepherd Hospital in Barrington and admitted there. He is not in any unit. He's just recovering right now, and he's dealing with poison control pretty much at the current time. However, and my client has not been able to get in to see him. She was able to get a wellness report on him from the Barrington police and go in on, I believe it was Saturday evening, for about 20 minutes. I mean, they're with COVID and everything, they're not allowing anybody in. And unfortunately, she's getting certain signals from the hospital about his care, things of the nature of, well, what we told you before, is still happening. He's doing this and this. And she said, no one has contacted me from the hospital. She's tried to contact them, and the communication is not good between her and the hospital. There are some issues where Chase suffers from Tourette's. He also has asthma. Whatever medications he's given obviously may have an adverse effect on him. Currently, at the moment, he's heavily sedated. Obviously, there may be, once he gets healthy, there may be another maybe another course of action taken. I don't know. But right now, what we're trying to do is come before you today, Your Honor, and have a temporary guardianship opened. And our problem is Tamara may have mentioned, or I was discussing with her before, we don't have a medical report because of the timing of all this. And two, to get Chase served, I guess we could do that today if we needed to, but frankly, it's hard to get into the hospital. There was a wellness check, as I told you, by a police officer from Barrington on Saturday. On Sunday, we got documents executed by Jennifer. I prepared documents Sunday. She came by our office, executed them. I was able to get the affidavit signed, or I signed an affidavit yesterday, had it notarized yesterday. Our timing isn't good, and part of that is obviously because of COVID, and just in the nature of how hospitals are operating. We're looking for a temporary guardianship on this. I'm sort of, I'm kind of, running into court for relief here to a certain extent, but also looking for the court's guidance on what will be allowable, but also in considering Chase's situation. He ingested a Zoloft, a prescription that wasn't his for Zoloft, and there was probably at least 30 pills he ingested. And he's in a spot right now. He's just recovering. He's dealing with poison control, but he's heavily sedated.
So what are the in the event I were able to make a finding that there was an emergency situation here and that the guardian were to be appointed on a temporary basis with the most minimum powers until we can have a doctor's report, until there is a service, perhaps a guardian ad litem, whatever. What are the most minimum powers that you are asking would be awarded, or what authority would at the most minimum amount would be? Because a broad scoped guardianship under these circumstances is not appropriate.
Understood. And Your Honor, that's why I didn't send you an order. I have a blank order here, which I want to get filled in because I wanted to go through as to what specific powers there were, because as you said, and I agree, we don't need anything that's broad. We need something that's specific, where it deals with the current, current medical care of him, and a discussion of decisions as to medication he takes based on other medications he's taking. And I think the concern is also, Your Honor, as maybe a background, I get what hospitals will do in this situation. And I think the concern that I raised with Jennifer, as well as Jennifer is concerned with, is just overly medicating. His well-being is important. And there's there's certainly a course of medical care that needs to be taken right now for his well-being. But at the same time, let's just not give him a huge amount of medications that are just going to, frankly, dope him up and just take him out of situations where he has no understanding of what's going on. In spite of the Tourette's, the asthma, he certainly, and he may have some mental health issues, but certainly he's somebody who's capable of functioning in society. But right now, that isn't happening. Frankly, he's drugged up, as to use my client's words. So I think what we're looking for, Your Honor, and I apologize being lengthy with the description, but I want you to understand what Chase is going through right now. But I think if we're able to have the power to assist in decisions regarding medications that are given, that are also consistent with current medications he takes, at a minimum, that would be beneficial, because then we get Chase out of a situation where he's doped up, and he's coherent, and and puts himself into a spot where he can make decisions. Right now he can't. There's no way, according to my client, and that's just a difficult spot for Chase right now, and no one's making decisions other than doctors who are just giving him drugs without knowing anything else. And I talked to Jennifer about, well, don't they know the background? And I mean, there may be information you can get off of the Epic system or other medical care systems that are shared between healthcare providers. But I've seen situations where, unfortunately, that even if they have the information, the hospitals aren't straight about it. I mean, and this isn't to say Good Shepherd's a horrible place, but the information that she's gotten from some of the healthcare providers does not jive with what's happened. They've said, oh, we've talked to you before, about, here's his care, and we're doing this just like we told you. She hasn't had any communication with them. I mean, it almost was, an act of Congress to get her in for 20 minutes. And she was able to get in also. She just texted me. She was able to get in yesterday for 20, 30 minutes again, but she can't make any decisions, and he's still not in a state where he has any understanding of what's going on. I think if we're able just to have her make medical decisions on his behalf, specific to maybe recovery, but also medications that will be provided to him, that would be helpful. Because then, at least then he comes out, he's going to come out of his fog eventually then, and come out of it, frankly, a lot quicker.
So, it's so hard to know exactly what the circumstances are here at this time, and what is appropriate treatment for this young man. But I will find that there is an emergency. I will grant the temporary guardianship on this limited basis, that your client, Jennifer, be authorized to have communications with the medical providers regarding Chase's health history and all current and recent medical circumstances, so that decisions are being made with full knowledge of his medical history and current prescribed drugs and so on. But I want to make sure that we get Chase served. I want to make also that she would be authorized to, that a medical report should be completed, and that she may receive and tender that medical report to the court. So I need a medical report. We need to get him served, and I may need to appoint a guardian ad litem so that we can make sure that we expand these powers as quickly as possible as are appropriate and necessary.
Okay, so right now, and I'm as I'm looking at the order form, and I just don't like to. There's a little bit more thought that goes into this order than normal, I would say.
Mm-hmm.
I just want to make sure that the powers of the guardian would be authorization to communicate with medical providers for Chase regarding his health history and his current medical state, and for decision.
Let's say current and recent, because currently we're not sure what, but his recent medical history prior to this incident.
Okay, so his health for Chase's health history, or communicate with medical providers for Chase's health history and current and recent medical state and history, and I'll just say be involved. I'm just trying to get some decent wording here. Be involved in decisions regarding Chase's prescription medicine. And go ahead. And
Also for purposes of obtaining a medical report. For the court. And that I'm not going to go beyond that at this point.
no, that's quite a bit, and I appreciate it. And I know Jennifer does too, Your Honor. Also regarding prescription medications, and I would just say also, and other over-the-counter medications. I mean, maybe they give him Benadryl. I mean, we all can buy Benadryl. Okay.
Yeah,
I imagine
so his current and recent medical history, should be shared with the doctors.
yes.
Yes, and so that includes all medications, whether by prescription or over the counter. But it's the sharing of the information that where my heightened concern is. At this moment in time, we have to leave discretion to treatment with the medical providers, but they need to have the information necessary to make the right decisions. So, but I'm also eager to get that doctor's report so we can determine what direction we're going from here. And then I'd like to set it out for a date pretty near in time.
Because, I mean, frankly, if he gets better, will he go to a facility? I mean, will he have outpatient or inpatient treatment? I don't know. Obviously, with something like this, I mean, we're at point A. We got to get to point B, but point A is getting him better right now and getting him out of the hospital. Point B is helping him, mentally, and how that's done, I don't know. I mean, maybe it's outpatient. Maybe he sees just a therapist. I don't know.
The father, Kurt Johnson, has he been noticed?
I don't think he has been noticed. They are divorced. He does not live. Chase lives with his mother. Kurt is not really involved, although Kurt was, I know, at the hospital on Saturday. I couldn't tell you if he was there yesterday with my client or not.
Because I also want to make sure that notice of the petition and the temporary order are given to Kurt Johnson.
Okay. There is there's a matter, there's a child support matter that's going on, and down on the first floor, Ray Rudnick of our office can see if, how they'll take service if the other attorney will. That's something, councils can work out, certainly.
Okay, I hope so.
Yeah, I would hope so too. I would just put it this way on your order. And I just want to make sure, and I'm not trying to beat a dead horse. I just want to make sure I get it correct, Your Honor. What I'll do is I'll have the order put together and say, temporary guardian is granted on an emergency basis with the powers and duties of the temporary guardian to authorize communication with medical providers for Chris's health history and current and recent medical state, and be involved in decisions regarding all Chase's medications, whether by prescription or otherwise, and share all such information for purposes of obtaining a medical record for this court.
So that's all fine. The only word I'm going to change is, instead of involved, say she can be consulted.
Okay.
So she'll be part of the communication. Where I'm hesitating is to give decision-making authority with knowing so little about what's going on. So
No, I understand.
Yeah.
I mean, she needs more than, she needs more than 20 minutes a day in the hospital, and she needs to be able to talk to the physicians, and she needs to be there early in the morning when the doctors are doing their rounds to be able to talk. And I get it with COVID, and I get what's going on, but there's got to be, there's got to be something where she's allowed, somebody has to be allowed to go in there. And obviously, your court's order, Your Honor, will get her far on this. I would say on the format or the form that I have, and I'm going back to pre-printed forms that we deal with, I would assume where it says the legal disabilities of the ward are as follows, leave that blank, I would assume, Your Honor, at this point.
Well, so I'm basing this all on the representations made by the petitioner, Jennifer Johnson, that he has been hospitalized on an emergency basis and is heavily medicated and unable to make decisions on his own behalf. So
should I just reference that, or follow as based on representations in the petitions filed by Jennifer Johnson?
And the affidavit for emergency hearing, yes.
So an affidavit of me, okay.
That's what I'm relying on right now.
Okay. No, and Your Honor, I certainly appreciate this.
So let's, and then the question is whether I appoint a guardian ad litem today or if I put this out for 14 days and we see what the status is. Maybe, I don't know if your client's going to be pursuing the petition at that point or.
Just looking here. I mean, I'm out, but certainly, I mean, look, it's not as if there's somebody else in my office who couldn't handle. I'm out on the 25th going forward. If it's not me, it's somebody else. That if it's 14 days that you want, that's fine.
So, here's my question. I can appoint a guardian ad litem today. That's going to initiate additional expense. I don't know where we're going with this.
I would probably say right now, hold off on that, just because of what you said, the additional expense, how they're going to, and I don't know, maybe you certainly have a better answer than I, Your Honor, but I don't know how they get into the hospital. If the hospital says, well, we can't do this because of COVID or whatever. I mean, granted, there's a court appointment here, but they may say, well, come back another time. Why don't you go visit him at his house or when he's out of here or whatever the case may be. I don't know.
I think they'll be able to, they'll get service in the hospital, but I don't know if 14 days is, I just think we have a critical period here where a lot's going to happen in these next 14 days. So I can set it over for status and, and at that time make an assessment about, and hopefully I would have the doctor's report at that time, make a determination whether it's necessary and appropriate to continue the temporary appointment, make a determination of whether or not a guardian ad litem should be appointed, So,
okay.
So I'm looking at July 1st. Okay. And then maybe you can have somebody else from your office.
Yeah. I mean, it's Zoom. Where I'm going to be, there's going to be Zoom. I'll look a little tanner than I am right now. So just not bragging, but I'm bragging. Certainly we could have somebody else if necessary. I mean, I've been dealing with Jennifer and we did, this is essentially a 2-minute drill as you can understand, Your Honor, but the situation dictated as such that we had to really move fast here.
Okay. I am eager to make sure that the medical providers have the information that they need to make appropriate decisions on his behalf. That's my top priority at this moment.
Understood. When would we have this temporary guardianship? Do we put it out for 60 days or is there another date, Your Honor?
We're going to put it to that next date, that July 1st date, and then I'm going to reassess it. Maybe it'll be appropriate to expand it at that time. Maybe it'll be appropriate to terminate at that time. I don't know. But
yeah, let's see how he is. I mean,
see what's going on.
He's not functioning now, that's for certain. And I get it. I think we all can understand that, but I think like you said, let's see where we go. Let me just, I'll just put in here, and I just want to make sure, I've got obviously what the legal disability section is, and we're at July 1st. And I'll have something put in here in the order that says this is set for status on July 1st. You're going to want the medical report by then, but the powers and duties are as follows. These are granted on an emergency hearing, and Jennifer is authorized to communicate with medical providers regarding Chase's health history and current and recent medical state, and she is authorized to consult in decisions regarding all Chase's medication, whether by prescription or otherwise, and to share information for purposes of obtaining a medical report for the court.
Yes.
Okay, is there anything about, the other thing is just having access to Chase 24/7. So she can go and, if it's 7 o'clock in the morning when the doctors make their rounds, she can be there, and she doesn't have to have any pushback from the hospital. She can be there for 4 hours instead of 20 minutes. I mean, if she needs to wait to talk to somebody, I mean, they're letting her in a very narrow window right now. And I think she needs
here's the thing. Until
Yeah.
I have some additional information, I have no idea what this young man's medical circumstances are, psychological circumstances are, for me to start imposing on the medical decision makers about what is or isn't appropriate for him. I have no idea I don't have enough information to start mandating time that mom is allowed to spend with him. Let's just take a deep breath. The most important thing is that she has the ability to communicate with them regarding these medications, share the information that she currently has. We're going to be here back in 14 days. We're going to have a medical report. We're going to make sure that dad has notice. We're going to make sure that this young man has notice. And then I think we're going to be able to chart a better course forward. Okay.
You're going to need something, obviously, we have service to dad, but also we need to have some sort of service by whomever to Chase,
He should
in the
be told
hospital.
by the sheriff's office. I mean, there's a possibility that it won't be, we're really supposed to give them 30 days, but I don't want to wait. Let's initiate the service today.
Yes.
There's a very strong possibility that it will be completed. If it isn't, at least we'll have some of these other pieces in place. And so we'll be able to, if appropriate, extend the temporary, make modifications to it as necessary. But at this moment in time, based on this little bit of information that I have, that's about as far as I can go.
Okay. Can we have somebody, I know you mentioned the sheriff, and normally we have the sheriff. Are we able to have, just because
A private prosecutor?
it's convenient, if we were able to have somebody from the Barrington Police Department serve, is that fine with the court, or am I overstepping a bound in doing so?
Do they do service for, I mean, no,
And,
I'm not going to order the Barrington Police Department.
No. I'm just saying, if we came back and it was some Barrington police officer, because of the nature of some relationships that she has.
Process server, that's fine. If you want to have the sheriff do it, that's fine, but.
Okay. Yeah. Okay, we'll get it done one way or the other like that.
Submit that order to the attention of Tamara, Tamara, as soon as possible, but certainly before 3 p.m. today.
Yeah, definitely. I'm going to get on with my paralegal, and we're going to get this worked up then.
And you have a nice vacation.
Thank you. I appreciate it. I think I'm going to see you during the vacation too. So
Have a nice.
All right. Take care. Thank you very much, Your Honor. Really appreciate it.
All right, so let's move.